very warm welcome to everybody in the room and everybody watching the live stream. I'm very happy to see so many people here today. I think that shows that although it has not even been published, the Digital Services Act is one of the buzzwords and hot topics of digital policy in 2019. My name is Alexandra Gees. I'm a Green member of the House from Germany, focusing on digital affairs. I'm a member of the IMCO committee on the Budget Committee. And this is, I have to apologize, this is not my normal voice. I'm running a bad cold, so I hope my voice will be up to the task until the end. I'm not sure of that, so just bear with me, please. I'm very happy to host this discussion together with Karin Melchior from Renew, because this is the first event of a whole series of debates on the different aspects of the Digital Services Act. We call this event series Digital Platform. So you're witnessing the very inception of a new public square, with the debate taking place very physically here in the room, but there's also a live stream, as I said before, so people can follow from everywhere. And there will always be a different co-host, because I believe politics is not only about stating and then possibly implementing your own opinions, but it's about exchange, about networking, about joining forces. So very great to start with you today, Karin. Thank you for that. What we want to do today is to discuss the upcoming reform of Europe's liability regime for hosting services and how platforms should be regulated. And you all know, if you're here, that in the past year, the Commission has been putting some effort internally into thinking about current problems around the regulation of digital services. Commission President Ursula von der Leyen has also been pushing the idea to revise the current e-commerce directive in order to create a level playing field, while countries like Germany and France are passing their own legislation. So that's one reason why we need a revision. But the other one is the fact that the e-commerce directive is 20 years old and was adopted before Facebook, YouTube, and Twitter even existed. In the meantime, the landscape of intermediaries has drastically changed. What once were considered hosting platforms are now the most profitable advertising machines the world has ever seen. So profitable that the combination of data they hold and the money, the profits they generate, are completely changing our economies. And at the same time, and this concerns our debate of today more closely, they are a public square. And this is what creates a dilemma for democratic societies. I think Liz has some very interesting examples from the UK general elections and the Stratcom findings from last week to illustrate what actors using the attention mechanisms of these advertising platforms can do to our public discourse. And at the same time, we certainly have very good reasons, which Daphne will hopefully illustrate today, not to allow governments to pressure companies to put in place voluntary mechanisms to fight harmful and problematic content. For example, codes of conduct, which we will know well in Europe, which completely lack public accountability and users' rights. So if the modern intermediaries are our new public squares, do we really want them to decide on our freedom of expression by their own terms of service, rather than by laws that can be challenged in court? As a result, the scale of legitimate speech that is taken down or blocked wrongfully has increased. And we're noticing a disparate impact on communities that already have less of a voice in the power structure of our society. And while so far many people in Europe didn't feel too bad about that idea, as long as the companies concerned were Google and Facebook, I believe awareness is increasing since TikTok is starting to become a player. While we could live with slightly different views on censoring nudity, most Europeans nowadays would shy away from censoring contents on the Hong Kong protests or LGBTI contents. So the upcoming reform is a chance to create a clearer legal framework for the removal of illegal content, for a clear framework of users' rights in order to avoid overblocking of legal content, and to create real accountability for platforms, and for more transparency and how the platform's recommendation mechanisms actually work. So in short, it is an incredible opportunity to become a global standard setter with clear notice and action rules that could have a global impact. And this is why it's crucial for the EU to get it right this time. And this is why we're very grateful to our distinguished guests from the US and from Ireland, which we will soon introduce. Before, just a few words on procedure, as we hope to make this as interactive as possible. In the first 30 minutes, Karen and myself will ask our speakers a few questions, and then we'll have around 45 minutes for an open discussion. So I would first like to pass the floor to Karen Melchior for her introductory remarks, then we'll move on. Thank you.
Thank you very much, Alexandra, and thank you very much for everybody that's taking part both in the room and outside, as you mentioned. I think it's really valuable that we have both Daphne and Liz here because they come with expertise and also experience from practical implications of how the business models and the use of the platforms, regulation and advertisement has been actually done in the referendum in Ireland, but also from a more legal and theoretical aspects from an academic view from Daphne. I think it's important that we look at both how we want to try and regulate platforms, but also the implications that platforms and digitalization has on our democratic debate and on our society. We often say that we want laws to be followed, but if we have a global square such as the internet and the platforms, then we also have a multitude of legislation, laws and norms that different countries and different groups want to have that the platforms follow. So this puts the platforms in a quite difficult in a quite difficult situation, and it also puts us as population and society in a difficult situation because which rules should we allow to supersede others? Alexandra mentioned TikTok as one platform, but we also have Facebook and Google and YouTube already having different types of legislation of what is legal and illegal content just within Europe. So if we want to have global standards, we need to find a solution or an approach that both combines the laws that have been implemented from our democratic societies, from our legislators, but we also need to find a solution that incorporates other aspects. And that's why it's quite important to continue having a multi-stakeholder approach, which is both used for internet governance. Both Alexandra and I attended the Internet Governance Forum in Berlin last week. And we have a problem in trying to link the multi-stakeholder approach to legislation. And if I had the perfect answer, then things would be easy. But things are not easy. So that's why I'm very interested in listening to the discussion today and hearing the input both from Daphne and from Liz. So looking forward to the discussion and also the discussion with the rest of the room.
Great. So I would like to start to introduce Daphne. Daphne Keller is the Director of Intermediary Liability at Stanford Center for Internet and Society. And her work focuses on platform regulation and Internet user rights. And she is an expert in everything related to platform liability laws, filters, global takedown orders, fundamental rights, terms of services issue. And you said yesterday, yeah, quite impressive, you said yesterday in a Twitter thread that you're currently trying to figure out the path to meaningful transparency and if there is such a thing as smart ranking regulation and a way to avoid half-baked laws in this area. And this obviously concerns us very directly because we are tasked to make these laws. So I'd be very excited to hear your thoughts on this.
Thank you. I've just denied being an expert in everything. And as I noted in that thread, the very things you're asking me about are the things that I myself am in the process of trying to figure out. So I'm very interested in hearing from the many serious experts assembled in this room their own thoughts on these questions. But to start with your second question about ranking, I was inspired to think more about this by the legislation that's been introduced in Germany, and there's a very interesting London School of Economics blog post on it yesterday by Natalie Hellberger and Patty Larson and some others. So the legislation proposes to have some fairness requirements for ranking, which I think is very much on the minds of many people as they think about the ways that platforms' recommendation systems or newsfeed ranking algorithms, how these sort of prioritization introduced by platforms influences the information that we receive and influences which speakers are able to find an audience. The challenge and the thing that I am trying to think through is to think about whether we are asking for fair ranking in the sense of competitive fairness, ensuring that different commercial offerings have the correct placement. Are we thinking about it in terms of diversity of viewpoint or a sort of media pluralism approach and ensuring that you see input from multiple perspectives? Are we thinking about it in terms of diversity of identity, of ensuring that women and marginalized groups have a voice? Depending which of those things we're thinking about, the outcome that we seek in ranking might be very different. And if the law just says be fair, but doesn't specify which, I think that leads to a lot of uncertainty. There's also a tension between saying that the ranking should show diverse perspectives and also saying, as various recommendations on disinformation have said, that it should prioritize information from authentic or legitimate sources. And that too is something I think for a long time platforms have wrangled with, but we as a society need to wrangle with and figure out how to negotiate. So I think, as I also said in the Twitter thread, I'm a little bit worried that some laws will get passed before we try to answer these questions. And so I'm very glad to be here in a place where people are trying hard to answer the questions. And I can go on about the transparency point, but I feel like that was long enough. So let's come back to that later, maybe.
Maybe Karen's follow-up?
I think it's a very good point to say, well, what is a fair ranking and what ranking do we want? Because at the moment, we've seen the platforms from encouraging democratic dialogue and democratic development to being a place where the dialogue becomes more and more polarized. While I can't pronounce his last name, Ghanem from the Egyptian Revolution, he, after a few years after the revolution, was very disillusioned with the way that the debate evolved online, because instead of having a discussion and reaching a compromise, you just became more and more polarized and more opposed to each other. And I think that is also a question, what do we actually as society want from this public square that we're establishing? And I think it's a discussion that we need to have as a society and not only as legislators, because it's difficult to put that into law, how that the ranking should be determined. And I'm not quite sure if it would be a follow-up for Daphne or for Liz. I mean, Liz has lived through the referendum debate in Ireland and also seen the way that the platforms had an influence there, and also the lack of transparency on who had been advertising for what. So, I mean, input from either of you could be quite interesting in follow-up on this debate.
Well, if you want to talk about ads transparency.
Maybe then I give you a proper introduction just before you start. Liz Caroline is the Executive Director of Digital Action that works to counter threats to democracy, and she founded the Transparent Referendum Initiative in Ireland.
Yeah, thanks, and thanks so much for having me here. Coming from and living in a small country, which sort of houses a lot of these companies, and yet where I think as a government, our government is sort of struggling to do this stuff unilaterally. It's very exciting to see these debates sort of happening in Europe. I think we need collective action to get through some of these. But to your question about sort of what was happening in Ireland during the referendum, and how do we think about what does a fair information environment look like? And when we're talking about platforms and the internet and democracy, I think what we're talking about is, what is the information environment that we think our citizens deserve for them to be active citizens and to be able to engage in debates and vote based upon a proper evaluation of the evidence. And to an extent, this isn't anything particularly new. We've spent sort of decades, if not centuries, figuring out what does electoral law look like, what does electoral finance law look like, and in particular, thinking about broadcast. In Ireland, and I think it's the same in a lot of European countries, we've made a decision a long time ago that we do not want access to the public sphere to be determined on your ability to pay. And so we have limits on political financing. We also have limits on paid advertising on TV and radio. At the same time, we have balance doctrines, which say that media must ensure that citizens have the right to balance information, and that's extremely well enforced in electoral processes, but it's also a feature during the rest of the year. And I think what we saw in the referendum in Ireland, and it came at a time which was sort of before the platforms introduced even the sort of the transparency mechanisms that they have at the moment around advertising. What we saw was people exploiting this sort of the financial loopholes and also the ability to try and dominate the conversation through using platforms. And I think at that point a lot of it was through paid advertising. I think we've seen an evolution since then, and if you look at what's happening in the UK election at the moment, even sort of some people who may have been involved in individuals who may have been involved in campaign tactics which were based on paid advertising have evolved their tactics as well, and are now thinking about, well, how do we use algorithms, and in particular what we're seeing in the UK is a lot of false accounts, people, political parties masquerading as independent fact checkers, independent groups masquerading as political parties, and we're just seeing this sort of like total breakdown in trust in the information ecosystem. And I think, when we're thinking about regulation, it's what is the role for national governments in ensuring that our electoral laws and that our broadcasting rules catch up with the changes in technology. But I think at European level, this is where we need sort of action to make sure we can actually see and understand what is happening on these platforms, how are decisions being made, how is curation happening, how is advertising happening, and it needs to be that two-pronged attack.
Yeah, just to follow up. So you're suggesting that transparency is needed to recreate trust in the information system? Is this what you would like to say?
It feels like a sort of a necessary but not sufficient condition. What my project did during the referendum was we had just under 1,000 volunteers who targets me to scrape ads that they were seeing, when in the kind of follow up to the election, when we were talking to Facebook, that they agreed to publish figures on how much had been spent on their platform during the referendum process, but they used our scraped data to try and figure out what kind of political activity had happened on the platform, and they were able to give us a figure, but it came, I think, 15 months after the election. So I think transparency has to be a part of it, but we also have a situation where platforms and business models were developed with sort of a particular frame in mind, as sort of advertising platforms or as communication tools, and yet they have somehow become the information ecosystems. They've become the mechanism through which people get information. They weren't built for that purpose, and so I think transparency is extremely important, but it also has to be a part of a bigger process of figuring out, well, do we need, in the same way we do in law, do we need to treat political speech, do we need to treat all of these things in different ways, and that may necessitate revisiting the way that business models work and the platforms are designed.
If I could follow up on that, I mean, one of the problems would also be that, as you mentioned, it would be 15 months afterwards that you got the information and the reports on what had been happening. I mean, do you see any opportunity of regulating and monitoring and having transparency in an effective manner? Because if you only get the information after the election, if you only get the information after the facts, then it's too late to change anything, too late to do anything. And is there any how to create a basis also for regulation? Because a lot of the regulation about balance of traditional media is also making sure that the information from both sides is available. But at the moment, it feels more like it's not a question of how much information is available, but making sure that information is not drowned out by other information. So it's sort of a two-pronged question. Sorry for being difficult. You both, how do we do it in a time-wise? How do we do it at sort of the accurate time? And then also, how do we deal with the fact that today it's not about getting the information out there, but perhaps it's more about making sure that it doesn't drown?
Yeah, well, I mean, saturation is an issue in politics and an issue that we try and deal with. To what extent that's done globally, or to what extent that's done on a national basis, I'm still not sure. But it does feel to me like there has to be a role for national values and ideas when it comes in particular to, I think, political speech. But to the point about transparency, I mean, I feel a bit like we live in a world where, as an advertiser online, you're granted secrecy until somebody has to try and convince enough people that right should be taken away. And you know, if you look at what happened during the European parliamentary elections, a lot of our partners were monitoring what was going on in the transparency platforms that the companies had, but also, you know, that they had other sources, and they could see that it wasn't working especially effectively. There were false positives, there were false negatives, and I just keep sort of wondering to myself, like, you know, why is the default secrecy and not transparency, and why do we have to fight for transparency rather than say to people, okay, you know, if at the moment we cannot determine, we cannot figure out what is political, what is not political, there's, you know, or issue based. There's so many grey areas. What if we flip the default and say, well, you know, and advertising, if you know, let's make everything open, let's make everything transparent. We can understand what's going on. We can understand the underlying mechanisms. And then, if we think there are certain types of advertising that have the right to secrecy, let's talk about that. You know, rather than fighting for every little bit of transparency.
Daphne, Liz mentioned the role of national ideas, and you mentioned before we would like to have, and she said it's an information system. They're not platforms anymore, they're information systems basically, so we should maybe regulate them somehow. You mentioned as criteria diversity, authentic or trustworthy sources. Then maybe the question comes in, what kind of diversity do we actually want? You know, do we want racists to have a right to have their contents shown to many people, or don't we? Should we have like human rights standards for that? And there the national ideas come back. And so maybe two questions on this. How does this relate to transparency? What should who should decide what these criteria are? You said before we need some debate, and I think that is true, but still, do you have any idea who might be someone to decide this? And then this is something which I think is very interesting in your work. What about cross-border enforcement of these ideas? You know, we wouldn't like, I think all of us would share the idea we might have some kind of European standard of what a landscape, an information landscape might look like, but we wouldn't want the Turkish or the Chinese government to enforce their values on us by a global platform. So how do we deal with all these factors?
That's a lot of factors. So maybe I'll start with the cross-border issue, because this is something I've worked on quite a bit. And we held a big conference on this at Stanford a couple of years ago and put out a proceedings volume, which I still think is useful. In a way, this is yet another issue that comes with consolidation and the rise of very major platforms occupying such a prominent role. Because if you have a platform that has a commercial presence and economic interests in many, many countries, then they are vulnerable to pressure from any government that is the gatekeeper for revenues from that country. And so the risk of one country's legal requirements and norms, or the benefits of one country's legal requirements and norms, depending how you look at it, flowing out of that country and into the rest of the world is greatly amplified by having consolidated multinational companies. And the risk side of it, which is what I'm focused on, arises when countries seek to suppress information that is lawful in other places. Of course, that can come with a benefit. Usually the suppression is because, for example, in the case of the CNIL Right to be Forgotten case, it was because of French authorities wanting to enforce what are defined as fundamental rights in Europe. So there is a tension between the values and rights that one country might prioritize and those that another country might. There was an interesting brief filed in the Equistet case, which was the Canadian global takedown ruling or global delisting ruling. The brief was from Human Rights Watch and another number of other human rights organizations. And what they proposed was essentially that if the order required one country's balance between human rights to override another country's balance between human rights, and both were equally permissible within the margin of appreciation under international human rights law, then the order shouldn't issue. So that's I don't think that is a final analysis, but I like it just because it is a starting point from serious human rights and international law experts thinking about how to move forward with this. The larger problem that I see, and this is a solvable problem, with the way that we are evolving the rules on cross-border takedowns is that the decisions are being made by courts in individual cases, and the courts don't have the black-letter law rules that they need to factor in the kinds of policy considerations that legislators and the rest of us think about. And there is a real gap where other institutions of government have great interests at stake: trade ministries, foreign and state departments, telecoms ministries. There are all of these other institutions that are affected by the consequences of cross-border takedown orders, but that aren't part of a deliberate government discussion, or at least so far as I've seen, have not been part of a deliberate government discussion about how to set those rules. So I think there's a real opportunity to move forward, maybe using forums like the Internet and Jurisdiction Project, in having this more conscious discussion that doesn't just come from the courts. On transparency, maybe just to broaden the topic beyond ads a little bit, because so much of what we care about is information sent in so-called organic posts, things that are not paid by advertisers. And sometimes it is information sent in often in a private Facebook group, or something that can't be researched without additional access. I think, first of all, we need to move beyond what is in transparency reports now, which is just aggregate data. It only tells us what the platform thinks it did, and it doesn't give any researchers the opportunity to look at the content that actually came down and say whether the decision was correct, or say whether the decisions in aggregate are having disparate impact on particular groups. Now, all of these important questions cannot be answered from the aggregate data in transparency reports. And so there's a real need for the kind of access that Liz was able to obtain in her study. But the legal barriers to that access are very serious. In the United States, doing scraping of the sort that Liz did could carry criminal penalties under the Computer Fraud and Abuse Act. Platforms have sued people under that and a half a dozen other claims, and so there's a barrier there. There's also a potential barrier that comes from the GDPR. The research exception rules in the GDPR turn on individual member state implementation. There are a lot of rules that are vague, and so I think platforms saying, oh, we can't be more transparent because of the GDPR, prompt a lot of ridicule among data protection experts. But the bottom line is that unless there is some clear guidance, for example, from the European Data Protection Board saying yes, this is okay, you cannot refuse to share this data on a GDPR basis, there will be a real barrier to meaningful transparency and research. So I think that is, on the one hand, I'm identifying a barrier. On the other hand, there's a pretty clear way forward to try to get past it, and people in this room have the opportunity to pursue that.
I think it's quite interesting to the first point on human rights, that it's a balance between different human rights, and then the suggestion being that we do a balance of human rights done in individual countries. I think this would, but it's also a question of who should then be doing the balancing of the two balances, because should we have an international institution or body that does this? There is, to sort of turn to Liz again a little bit. I mean, you've said in a talk that on one hand there is technology enabling and empowering global communities of interest to share ideas and find like-minded people. But on the other platforms' decisions to promote certain content, to advertise against certain things, has huge impact on our democracies. So where do you think we should be drawing the line?
I mean, this is the million-dollar question, right? Is like, I think everything that we end up having, every conversation that we end up having about this is about drawing lines. And I think so from the work we've been doing, I mean, I think I can see sort of maybe two sort of lines. And so when we started getting the data in during the referendum in Ireland, one thing that was quite noticeable to us at the beginning was quite a lot of organizations, especially small organizations, were using social media in order to organize local events, get people together, try and recruit volunteers who could go out and knock on doors, which is a big part of Irish politics, get people down to the parish hall where there was a talk happening or some organizing, which is exactly the kind of activity that I think is extremely important in a democracy, and that social media has really enabled. As we were getting sort of more data in and closer to polling day, we started to see some of those kind of slightly darker trends coming in. So we did see US-based organizations that had US addresses, actively targeting Irish voters, saying vote no, or vote, to vote a particular way. To the jurisdiction question, we highlighted that with 4 authorities in Ireland, and every single one of them, they called me and I said, email me back because I need this in writing. Every single one of them replied and said, that is not in our jurisdiction. Nobody could do this because this was a transaction happening between a US-based organization and a US company. It didn't fall under Irish financing law. It didn't fall under any of our jurisdiction. What we so I think we ended up sort of highlighting this with the platforms, and to their credit, Facebook took a unilateral decision that they were going to stop overseas groups from doing this activity. In part, they did that because they said there was ambiguity. There was ambiguity in the law, but as you can imagine, I was getting a lot of DMs, emails, private messages, everything from organizations who had been stopped, and I engaged with them. And an argument that one of the pro-life organizations in the US was making is, we are a part of a global community of interest. There are, I think in particular, people who maybe hold a pro-life position at the moment in the US and in Ireland sort of find more resonance with international communities than they do necessarily domestically. And, thinking of how Ireland has changed in the last 20 years, a lot of that has come about because minority interests have been able to access and get support from communities around the world who've backed them up. Where we draw the line, though, is when that becomes somebody who doesn't have to live with the consequences of a vote trying to determine a constitutionally binding referendum. And to me, that is a very clear line. A second one is, when we go from having the ability as a group, as a community, to create an online presence, to be engaging in debates, and to be doing that in good faith, and whether you're doing that synonymously or under your true identity, I think that's an extremely important avenue that people haven't had before. Again, if you're an LGBT activist in a repressive regime, the ability to build a brand around a name, doesn't have to be your own name, but to be able to engage in discussion is without having to reveal your true identity, is quite an important thing. What that is different from is AstroTurf campaigns, which are either creating the sense that they are indigenous, that they are local groups, that they are a part of a community, that they represent people who they don't, and that can be entirely false and entirely constructed. And again, that's where there needs to be there needs to be another line. If during the European parliamentary elections in Ireland, we had one candidate who was successful, but she's LGBT, and there were websites set up that Google sold ads to make it top of the top of the search results, not just SEO, actually advertising that was done by somebody who wanted to try and denigrate her character, and so the ability to just create what we have in the UK right now, which is just a first drafts term of information disorder. It's not just that you have all of this fake and false content or things that look like grassroots that aren't, but it's also the undermining people's trust so that they don't believe anything that they see online. That's where we have to draw another line. There are a million other lines, and we need to kind of figure out what they are, and these are those discussions. But the one thing that I do know is that we cannot allow private companies who have a different goal, they have a different constitution. Their goal is to make money. Their goal is to be as big as possible, to get as much data as possible, to sell as much advertising as possible, to keep our attention for as long as possible. It cannot be their responsibility to be figuring out where all of these lines are.
Daphne, I've seen you taking a lot of notes. Would you like to briefly comment? Otherwise, I would open it up to fulfill the promise to give you enough time for your questions.
Sure. Well, I think I just want to call attention to one tension here, which is around the world, and maybe particularly in the US, because of the disparity between our law and our social norms about what is appropriate to say. There is tremendous pressure brought to bear on platforms to take down content that is harmful but is not illegal. And that means that the platform is being asked to take down something that is not defined by law, but is ultimately going to be defined by the platform's own discretionary judgment. And that may be a good thing in many ways. I mean, in the US, this is how you deal with racial epithets. This is Holocaust denial is legal in the US. And so if you believe that it should come down from platforms, it has to happen based on the platform's discretionary terms of service. But the problem, the sort of systemic problem for a democracy with that, is that by asking for these extra legal takedowns from platforms, we create or exacerbate the situation where the decisions are made based on rules created by a private company instead of a democratically accountable body. We are creating the situation where the takedowns are subject to rules that are not reviewable by a court and not subject to constitutional or fundamental rights-based challenges, at least in most jurisdictions. And so that is a deep tension that I think societies need to wrestle with as we think about what it is that we want platforms to take down and how much we want to transfer authority over speech into the hands of entities that, as Liz describes, are subject to commercial priorities that will, probably at best have majoritarian impulses because that's what advertisers want, but at worst will be under pressure from a government in a market they want to enter, or some other source. And so, well, I don't have an answer to that one. It's a pretty profound question, I think.
So it's up to you now. Who would like to break the ice? First question. Go ahead, Krishnan.
Me. Yeah, I'm Andrus Ansip. I'm former commissioner responsible for digital issues. I think everybody's thinking why this Digital Services Act is needed for us at all. And the answer is quite simple according to my understanding. 20 years ago, when we got e-commerce directive dealing with platforms now, we didn't have social media platforms. We didn't have collaborative economy platforms at all. And during for the first decade, even 17 years, it wasn't an issue that we didn't have exactly rules dealing with the social media and collaborative economy platforms. But during the last couple of years, we got many of different interpretations of e-commerce directive. We all know about Netzstege you have in Germany. So there are some possible conflicts also with the EU law between this Netzstege and the EU law. Just recently in France, they got new rules dealing with illegal content on platforms. In the United Kingdom, there are some kind of rules dealing with illegal content on platforms and so on. Very soon, maybe we will have 27 different sets of rules dealing with illegal content or hate speech on platforms and so on. This Digital Services Act, according to my understanding, has to be a regulation. It means we have to keep harmonized markets, harmonized rules in this single market in the European Union. So, not directive, but regulation. So, we have to update definition of online services. Then we have to keep those main principles according to e-commerce directive. It means country of origin principle has to stay. It means prohibition of general monitoring has to stay. We have to keep limited liability principle. As we all know, there are some people who would like to put full editorial responsibilities on platforms. But platforms, it's not only about Facebook and Amazon and Google. We have 7,000 different platforms in the European Union. And when putting full editorial responsibilities on platforms, we can easily kill our own 7,000 platforms. Autoscout24 selling second-hand cars. So I have old Nissan Datsun Sherry. Maybe I will get $30, maybe even $50. I have to put also photo on this ad. It means I have to go to car wash. But it's at least 12 euros. No, I will take some protected, copyrighted photo and put this on this platform. So who will be responsible? Me. Sorry, I have just old Nissan Datsun Sherry. Platform has to be responsible. Or mileage and manipulations with those issues. Not me. Ask platform and so on. We can easily kill our platforms when putting full editorial liabilities on platforms. Then it's quite clear we have to bring more clarity in procedures connected with that notice and action principle. Today, as we know, according to court rulings, those platforms who are not even trying to understand what is happening there, what kind of illegal content was uploaded on my platform, those are innocent platforms. They are passive. They didn't know something wrong was happening in those platforms. They are not responsible. But those active platforms who would like to know what is happening there in my platform, to fix some problems before they will become as a huge problems. Those platforms knew that there was something illegal on those platforms. They are liable, they will be guilty. So we have to change this situation.
Commissioner, do you have a question? I'm sorry, but in order to give everybody time to speak, that was quite a long intervention. I realize you had a crucial role in the past legislature as a commissioner, so I'll let you speak, but I would ask you to be brief.
My question is very simple. Do you agree with all what I said right now?
You know, I will respond very briefly on the point about filtering. Just to call attention to a real challenge that is facing European legislators and courts right now as a consequence of the Glavišnik-Piecek case that came down from the CJEU a couple of months ago. And I have a blog post up about this for anybody who would like to read a more detailed version of this point. But essentially, the court approved a filtering mandate for Facebook under Article 15 of the e-commerce directive, said that this particular order didn't amount to a general monitoring obligation, and then didn't go through the analysis of what the fundamental rights constraints might be. And as probably a lot of people here know, there are real concerns about filters because of their inability to understand the context of reuse of content, having a sort of over-removal consequence, and increasingly there's concern about consequences with real disparate impact on people based on their language or ethnic background. And so this big looming question about the fundamental rights analysis remains for lawmakers to think about and for the Austrian courts as this case continues to think about. But what the court said, and actually I should add that Alexandra Kucheravi, who is here in the audience at Leuven, has written very, very well about the fundamental rights questions with filters in the EU. So you should all read that. But what the court said is, to be consistent with Article 15, you can only order a filter that's capable of taking down the right thing automatically without requiring additional human review and judgment. And that mandate under Article 15 is in profound tension with what the Council of Europe and other human rights sources have said, which is to make a filter comply with fundamental rights, you really need humans to check its work and figure out what mistakes it is making and correct those. And so for anybody moving forward with legislative mandates that potentially involve filters, there's this great bind now where if you want to comply with Article 15, you are likely in tension with, at minimum, and maybe violation of fundamental rights requirements. And I don't know what I would do in your shoes other than maybe not mandate filters, but that's me. And I think it's a real problem to solve going forward.
Other questions or comments?
Just very quickly, I mean, I think it's always reassuring to hear people who are involved in sort of existing pieces of legislation or regulation that we have just sort of come out and say, listen, it doesn't work anymore. This isn't fit for purpose. I mean, I think there's a million questions and there's a long process between now and when we actually end up with the DSA enacted. One thing that I'm sort of concerned about and thinking about at the moment is, to Karen's point, what's that process, and how do we make sure that process is, you know, I know multi-stakeholder is sort of the word du jour here in Brussels, but like, you know, if we're looking at it in very practical terms, we can see it in Dublin, we can see it in other European capitals, we can see it here in Brussels. There is a big power dynamic which is going to happen in the context of this regulatory process over the next 6 months. There's some great experts in the room. There's Access Now, Edry, Mozilla, other people who are doing a lot of thinking about this. They're thinking about it in terms of what's the ideal outcome. But I think, you know, these debates are going to be characterized by people who sort of understand the issues. I think there's a lot of political will that I'm hearing in member state capitals and here in Brussels for something to change. What exactly that looks like is going to be a big old fight, and one which is going to be characterized by very unequal power dynamics between people who have expertise, in particular those on maybe on sort of civil society or academia, and private companies who have extremely vested interests in particular outcomes. So I think it's going to be an interesting year.
Yeah, I think that was a very important point to make.
Just a question for Liz, picking on you because you're Irish. A lot of the discussions around the Digital Services Act are motivated by this idea that there's increasing fragmentation between different member states going in different directions, and so we need a kind of a new EU-wide solution. And when you speak to people in the national jurisdictions, oftentimes you get the reaction informally that the reason why they're passing laws like Next Day Gay and the French hate speech law is because they're frustrated that the Irish government isn't doing enough to enforce laws against the companies that are established there. And in your interactions with the Irish government around the referendums and subsequently, have you got the sense that they are feeling that pressure and that they are willing to move forward? And do you think that they're prepared for this kind of unique role they have in the DSA debate?
Thanks, Owen. I think it's very difficult for a small country where tens of thousands of very high paying and high income tax paying jobs are to take a stand against companies who have GDP level cash behind them. And you know, if we're looking at our information commissioner, who Helen Dixon, I have a lot of time and respect for, and I think she's being strategic. She's working with colleagues. It's extremely difficult as a nation of sort of 4 million people to go up against that might. I think so. In my interactions with government, there's a real frustration. There's a genuine frustration, I think, in particular in Parliament with what's happening. It's similar to the kinds of conversations that I have with public officials and with elected representatives elsewhere. Brexit is the reason that everything has slowed down, frankly. I think the politics gets in the way. I think on civil society's side, we need to do a bigger job of making this a priority issue and giving elected representatives in particular the political cover for them to say, okay, even when we have an ecological crisis, we have a housing crisis, we need to think about jobs, we need to think about things that people care about when I'm talking to citizens and to voters. We need to make sure that this is higher on the list, higher on politicians' list of priorities. But also, frankly, I mean, this is why I think there is space for Brussels to be stepping in, because acting unilaterally, we saw what happened in Canada when the Canadian government introduced legislation around political ad transparency. Google just pulled the entire product from the market. This is the kind of power that companies can hold over marketplaces, and so collective action backed by citizen demanding it has to be the way to go.
If I could add another plug for paying attention to Ireland, I think a lot of people pay attention to what the Irish DPA is doing, because the Data Protection Authority, because of the establishment of major platforms there. But we should also all be paying attention to what the media regulator is doing, because the Audiovisual Media Services Directive vests this tremendous authority in the Irish media regulator for platforms like YouTube that are established there. And it is, as I understand, a relatively small, like 30, 40 person agency being given authority that will affect people throughout Europe, and that is incredibly hard. And they've put out a proposal for how they hope to exercise this authority that I think has a lot of pros and a lot of cons. Our European Intermediary Liability Fellow, Joan Barata, has published a series of blog posts in exchange with Mr. Lubos of ERGA on the questions of the AVMSD implementation as it affects platforms. But I think it is high time to pay a lot of attention to what's going on in Ireland in that respect.
There was a question on the right.
Hello, thank you very much for great presentations. I would like to go back to the topic of the meaningful transparency. And of course, this is something we, the civil societies, we were advocating for this now for a while. And we advocate for meaningful transparency, not only for online platforms, but also for state actors. And I would like to know, and I know that this is a very tricky question, but if you, each of you, could mention maybe one requirement or criteria which you believe would eventually lead to meaningful transparency, or it would be a great starting point, it would be extremely helpful because it's something we are constantly juggling with here while positioning ourselves. Thank you very much.
Well, I will start with a plug for the state transparency mandates that are in the Parliament's draft of the terrorist content regulation. I look at legislative proposals all over the world, and I've never seen such good provisions for transparency by the government side of takedown interactions. You know, it lists out requirements for law enforcement agencies to say not only what they've requested taken down, but also how does this correlate to actual prosecution of bad actors and investigation of terrorist or potentially terrorist activities in the real world. So I think we actually have a very good model there to build on for the government side, and maybe more broadly for the notifier side, you know, even if it's a private entity requesting content takedown of the transparency picture.
And just to add that, I mean, I think from a very pragmatic point of view, I mean, I think transparency and information on understanding exactly how the business side of things works is extremely important. Like, I think there's a good bit of momentum around the political ad sort of idea, and I think there's an acceptance of that transparency is needed there. I mean, as I was saying before, where do we draw the line and the barriers around political ad transparency? And actually, there can be quite a lot which is problematic with general transparency. I don't know if you saw in the Washington Post yesterday, there was a story about how lawyers in the US are pushing out disinformation, false information about the safety of PrEP, which is medication that you take in order to prevent the contraction of HIV. And so misinformation about the safety of PrEP is being pushed by law firms in order to try and build class action lawsuit cases, so for financial gain. And we see this all the time, things that kind of sit between commercial and non-commercial. And so I think, you know, you know, and obviously there was a lot of stuff in the US last year about housing access and sort of targeting based on racial criteria that was excluding people from accessing housing. So I think, you know, using this moment that we have, which in part has been built by Access now, by Edry, by others, that's where there's an acceptance of the need for political ad transparency and sort of pushing that so that we're getting the information that we need, even as a prerequisite for figuring out where all those lines are and what kind of regulation we need.
I think it's important to make sure that we have the information that we need to actually know what's going on. I think it was quite telling that, Liz, you mentioned that you had actually been, or one of you mentioned that the scraping that you'd done on the Facebook ads during the referendum was actually the basis for what Facebook was then using for their transparency report. So we need to actually have the information about what's going on before we can talk about transparency, because otherwise it's transparency into a void where there is no information. And then I would warn a little against saying, oh, we only need to regulate political ads, because as you mentioned about PrEP, there is also advertisement and false information that is non-political, that is also harmful. You could also say, well, information about vaccines is also can be disinformation and harmful if you prevent people from vaccinating their children. So I think we need information to actually have the transparency, and then we need to have an oversight over what's going on. And I'm not sure if that's a criteria for meaningful transparency, but that are at least some prerequisites.
Thank you. I think you were. I think you were first. Then I keep someone there, and second on the list.
If you could introduce yourselves, that would be great.
Sure. My name is Cornelia Kutter. I'm Senior Director for AI Privacy and Digital Policies, and I work for Microsoft. And of course, Microsoft has multiple different services. We don't have a general purpose social media service, but in our services, we are also looking at what is the purpose of a service, and that goes a little bit to the terms of use that are often defined by the purpose. So if we have like an Xbox, for example, which is gaming, which is more directed to children, safety will play a really, really important role in our decisions, how we draft terms of use, versus a search engine, Bing, where access to information is sort of highest. I have two questions for the whole panel, really. The one is, how do you define this, the terms of use versus legislation? Because there will always be in a space that companies will have to define how they describe their services and their purpose. That's the one thing. And the other one is your general opinion around what we have seen in the last couple of years or months, that there is a more focus on vertical legislation, so terrorist content, eventually now sexual child abuse material legislation. In other parts, it's codes of conduct like hate speech or more general child protection. How important is it to have this more fine-tuned vertical legislations in a more horizontal DSA conversation?
So on terms of service versus legislation, I feel like all things in this space, it relates to competition, right? The bigger a platform is and the more important a role it plays in public life, the more legitimate interest there is in what its terms of service say and what information and expression is permitted or prohibited. And so I think this is sort of part of the thinking of the German courts enforcing the Drittwirkung doctrine in the cases ordering Facebook to reinstate some content. So you know, the bigger a platform is, very crudely speaking, the more legitimate public interest there is in using legislation or courts or some public governmental mechanism to shape what the terms of service say about use of the platform. On vertical legislation, you know, it's really hard. Like, no matter how you slice it, it is difficult to define the rules because we're talking about the rules for every aspect of human communication when it is rendered digital. You know, I mean, nobody has ever tried to write rules like this before, and the problem is, you know, it's not quite as vast as all of human behavior, but it's a really significant slice. And so I think, you know, even assuming that the approach is horizontal, which is my impression of a likely DSA direction, the rules for what you want platforms to do are different depending what kind of prohibited content you're talking about. So if it is something like child sexual abuse material, which is very harmful and very recognizable to non-experts, then a rule that says, hey, platforms, you are capable of recognizing this and acting immediately, and maybe you use cruder tools in pursuing it, such as filters, you know, that seems more viable. If, on the other hand, you were talking about speech critical of a politician, no offense to anybody in the political fields, you know, maybe that is a situation where you don't want a platform to be the one exercising the judgment, and you do want to have a process where it is a court or public authority that makes the assessment. And so even within a horizontal framework, I think it is important to recognize the difference between different kinds of harms and the different kinds of benefits from potentially lawful information that gets taken down.
The one thing that always comes into my mind when I think of the terms of use versus legislation sort of the discussion is, what happens for people who can't trust their governments? And in sort of previous lives, I've spent a decent amount of time working in sort of sub-Saharan Africa and different places where, you are going to be relying on the platforms on terms of service, not your national legislation. And I mean, I'd love to see that perspective be a part of the DSA conversation as well. I feel like people from the global south get sort of mentioned or discussed in these debates a little bit. I think in particular around that question of pseudonymity or kind of fears that regulation in Europe may embolden unethical leaders in other contexts to start to introduce repressive rules about internet access and internet use. And I think there's a discussion there that should be had, but I think it should be had with those people in the room, because sometimes when I hear those people being talked about, it's used quite cynically as an excuse to try and avoid regulation. But what I do think, I just think, in how do we figure out how A, to have good terms of service, but also B, how they get implemented well as well. Like the NATO Stratcom's report that came out on last Friday was quite interesting, because it was pointing out that I think there were various fake accounts that were set up in a kind of research capacity to do all sorts of things, just to sort of test the limits of what people could get away with, and then they were then reported. And most of them weren't taken down even when they were reported. And there was some good investigative research by the ENAR, the European Network Against Racism, where people who've been designated as sort of super reporters for hate and for racist content online monitored what was happening when they were reporting things that breached terms of service. And even when the terms of service are there and sort of programs are put in place so that people are supposed to be jumping the queue in terms of reporting, there was very little difference between the levels of content removal that were happening between just anybody doing reporting and people who are deemed to be experts doing the reporting. So it's also like, how do we do that, and how is that going to happen? How are terms of service going to be implemented across languages and in different contexts? We know in the horrific things that happened in Burma, and it only emerged sort of afterwards that there was extremely limited language capacity within Facebook at the time. And that indeed, despite repeated efforts and people, going to California to highlight that this was an issue, very little action was taken. So it's getting the terms of service right, and it's figuring out what does enforcement look like in the real world. If you have a company and you want to go in to a context like Burma and offer your product for free in order to achieve dominance, you need to think about that very, very carefully, and you need to approach that with sensitivity and with an understanding of the issue, and think about your terms of service and think about implementing them in that particular context.
Just briefly, I think we need a horizontal discussion about what filters are, what general monitoring is, which kind of different types of platforms we have, because we are lacking an understanding of this. So we're talking about things, but we're actually talking about different things. And I think the case law coming out of the European Court of Justice might actually also not actually be entirely helpful, because if general monitoring is only if there is a human involved, then we have a lot of what I would seem as general monitoring by filters that is not being included. And also we need to find out, well, what kind of filters do we want, and how good filters do we require when we use filtering? because as Daphne also mentioned, I mean, you need different tools for different issues. I mean, child abuse is one thing, disrespectful speech against politicians is a completely different thing, and we shouldn't be using the same tools for both. And then, as Liz remarked, we should always consider that if we're allowing for tools that we imagine should be used for the best intentions, that they may also one day be used with the worst intentions in mind.
There was a question on the left of the room.
Yes, hello. My name is Nora. I'm from a consultancy called Teneo. I have a question related to the need of speed, because we have a lot of discussion in the past and currently about the fact that the content circulates very quickly, and so there is this problem of taking it down when it is legal, but also when it is harmful, as quickly as possible. So since you seem of the idea of involving courts rather than companies, I was wondering what's your opinion and what's your position on how to take down content with reasonable speed when needed, given that not everybody can file an injunction. So, yeah.
I guess I've already called one thing a profound question, but I think this one is also a profound question, because what human rights and fundamental rights guidance forever has said is that when you're adjudicating an allegation that somebody's expression is illegal, you need full and fair process. You need a court to look at it. That takes forever, right? And there is no way that you could have a full and fair court process for all of the millions of takedown requests or things flagged by filters that are reviewed by platforms. Like the courts don't possibly have the capacity to provide what has been sort of the bare minimum for adequate justice in the past. Neither do the platforms, but the platforms conveniently are not held to fundamental rights obligations, and so they can do a quick and dirty version of justice and adjudication. And to date, we've kind of said that's a good thing, you know, and said, okay, platforms, you do it because you can do it quickly, but the cost of that is a loss of full and fair adjudication. And there is not an answer that leads to the kinds of resources being dedicated to each and every question that we have seen as a minimum for fairness in the past. And I don't think anyone has an answer for a way forward. The thing that's getting a lot of attention right now is the so-called Facebook Supreme Court, the Independent Oversight Board. They will, at best, maybe they will go down in flames and be politicized and not legitimate. But at best, and I hope the best for them, they will be able to resolve a tiny, tiny minority of disputes and offer guidance for the rules for subsequent disputes. So this sort of outsourcing it to them is not a solution. Particularly out of Germany for a while, there were ideas about other kinds of independent arbitration. I think anything that moves it out of platforms doing it, because nobody trusts them, and out of governments doing it, because governments aren't allowed to do quick and dirty justice, is worth exploring. But it's hard. It's incredibly hard.
Other questions, comments? No, then
possibly follow up on what Daphne was saying. I mean, it would. I asked Didier Regnez, the upcoming the Commissioner for Justice. He's now actually in function, about how to deal with exactly this question. And I mean, one of the things that I was considering when asking him was, could we have some kind of an ombudsman institution, or sort of have something that is part private, part public, to help the platforms create better decisions that can then serve as a practice. Because one of the things that I worry about is also that, yes, platforms can make quicker decisions than justice systems and politicians, but it also feels a bit like politicians sometimes shy away from the difficult questions and say, well, the platforms have to deal with that.
I think I overlooked the question over there.
Hello. Hi, my name is Jakob, and I represent News Media Europe, which is a trade association for the news industry. Thank you for the conversation today. I think it's very helpful. I think coming back to sort of a more basic level, which I don't think was said perhaps clearly enough, is do you think that there is, under the current liability framework, enough incentive to tackle problematic content? Because the way we see it, there's been systemic shortcomings whenever it comes to self-codes of practice and conduct and so on across a range of all sorts of types of contents, whether it's disinformation, copyrights issues. So we also think at the same time that a primary liability is not justified because these platforms are obviously not producing content, but we also think that perhaps it's wise at this stage to increase the level of liability within the secondary liability hat. And so it's a bit of an elusive middle ground, but the question is how could you go about that? And indeed, one of the issues that's being floated around a lot is whether we should look at platforms from about whether we should designate some of them as being systemic in nature because of the major bearing that they have on society now across a range of issues, whether it's cultural, political life, or economic life, because they also act as marketplace regulators. And then whether we should derive from that additional duty of care standards or obligation, which would then perhaps tie into their ability to benefit from a safe harbor. And one other issue that I wanted to raise is that when you speak to a lot of platforms in Brussels, and they will tell you, well, the reason why we can't do more is because we cannot have proactive measures in place, otherwise we don't benefit from the liability exemption. But I know on the US side they have this Good Samaritan, but nothing tells me that the US internet landscape is a safer place, is cleaner for it, basically. So is that really, would that be giving some of the platforms a carte blanche to keep turning a blind eye to problematic content again?
So I think the incentives of the current system have created a number of things that we should all consider problems. One is an incentive to honor any takedown notice, even if it is identifying content that is actually lawful. And for lack of better transparency, we don't have very good information about what is going on in cases of allegations of, say, defamation or hate speech. But we do have very good data about what happens in the realm of copyright, because that's the one area where there's much more transparency. And study after study shows a pattern of overreaching takedown demands and then compliance, because the incentives for any given platform are to protect themselves and not take a risk on speech that might be unlawful or that might lead to costly litigation or disputes, even if it is lawful. And so there's that incentive problem with the current system. The other incentive problem, and this is tougher, and I don't have a good solution for it, is when laws are either vague or vary from state to state, as they necessarily do within the EU because of different member state rules on free expression exceptions and limitations in many realms. The easiest thing to do if you are a platform is use your terms of service to prohibit a superset of all of those things and to make sure you don't have to make any difficult judgment calls. And so the current incentives drive toward over removal and over prohibition in that sense also. So I think there are a number of incentive problems with the current system that I hope can be redressed through the DSA with things like, at a minimum, counter notice provisions for those who have been accused of speaking unlawfully. On the question of duty of care, I have a question here, and this is not an advocacy point, it's something I'm just trying to figure out, which is if the law says that to meet your duty of care, you need to do a set of things, like maybe have some kind of proactive monitoring or have your employees investigate things. Can those things that the platform does then be held against it in regular litigation? When somebody sues a platform for defamation, for example, the first thing they will say is, oh, you aren't sufficiently passive to qualify for immunity because of that proactive thing you were doing to comply with the duty of care. Or you knew or should have known about this particular piece of content, and therefore you lose your Article 14 immunity because of the things that you were doing to meet your duty of care. And I very much want there to be a resolution to that, because I think in general duty of care models make sense to me as a starting point, particularly in European legal frameworks. But I do think there is a puzzle to be solved about how you can simultaneously have a duty of care and have a model for ordinary liability without one really messing up the other.
And there is a case in Ireland at the moment, actually somebody's taking against Twitter, I think, on those grounds, sort of saying, you know, I reported, and this is, Ireland has quite good or bad, strong defamation law, and under defamation law saying, I reported this multiple times and no action was taken, therefore you know, you were actively engaged. I think that's making its way through the courts. But I think when on the conversation of incentives, I think we talk a lot about sort of like a binary thing of content removal or takedowns. And what I'd like to see, and I think what the duty of care concept in the UK, whatever you think about it, what it's trying to do a little bit is to talk not just about that sort of binary choice, but also what are the kind of the active, like what is the curation that's happening, and what are the kinds of incentives for service users that are created by algorithmic design and by all these other issues. And one thing that keeps coming into my mind is when do you remember? I think it was last year. Was it around one of the Mars sort of successful Mars things? I'm not a science person, but there was a female scientist who went viral because, you know, like because she had been a part of it, and it was quite a nice moment. But if you searched her name in YouTube on that day, I mean, she had her own TED Talk that had, you know, a very large number of views. But what came up on top of that was a sort of a conspiracy theory about her that had much more, you know, much fewer people had viewed it. It was from a much less reputable source. And yes, because of the virality of that particular piece of content, that particular moment, we think, that ended up sort of being basically actively spread and sort of made more prominent for people who were looking for information about this person. And so I think, you know, in the context of the DSA, what I'd like to see as well is, you know, us getting beyond this sort of like, you know, this binary question and thinking, well, what are the kinds of responsibilities that we want to have, again, beyond transparency, for that curatorial role that we know that is an active part of what platforms do, and in a way what they do really well. That's why Google works when we want to try and find something. But, you know, like there's all of the things that we know about the incentives that are created by that also lead to people posting more outrageous or more offensive or other content.
Great. Thank you all very much. I think we have tons of questions left to be answered, but unfortunately we were running out of time. I'm sorry, we have to leave because there's the next meeting starting at 1:30, so by the time we leave the room, we're already late. I'm really sorry, but I think we'll be available 5 minutes out of the room, so we can do that bilaterally. I think we still have a huge debate ahead, and we talked about governments and companies as the actors of this debate, but I think what we are showing you today and what is very important, and what Liz mentioned in the beginning, that civil society is a very important actor and that all communities have to be brought into this discussion, and this is what we are going to try to do next year. And we count on your help for the DSA. Thank you very much for coming. Hope to see you soon again. Special thanks to our guests.